first case on the calendar is International Security Management Group versus Rolland, Inc. Counsel, you have 10 minutes. Would you like to save some time for rebuttal?
I'd like to reserve 3 minutes for rebuttal, Your Honor.
3 minutes, perfect.
Good morning, Your Honors. May it please the Court, Jedediah Vanderplat on behalf of appellants, International Security Group Management, Inc. and Mr. Acuna. We're here today on the appeal of the trial court's denial of our motion to tax costs against appellee Bill Rolland, Inc. That motion, that order is due to be reversed because appellants recovered a judgment against appellee, and under the cost statute, that is the only prerequisite for obtaining costs, is that recovery of the judgment. Now, the trial court got confused because the individual plaintiffs, separate from Bill Rolland, Inc., recovered a judgment on their own against our clients. Now, that separate parties recovering a judgment in no way detracts or takes away from the fact that our clients did recover a judgment against the individual appellee that's present here today, and therefore were entitled to costs.
Now, is the statute in question, the word of cost is not discretionary, correct?
That's correct, and this court has held that multiple times. In Tacker v. Matthews, 6 v. Clark, and multiple occasions. There's no discretion baked in. It's solely a matter of applying statutory language to the case. And in this case, the only statutory language that matters is the party recovering judgment. Our clients recovered a judgment and therefore are entitled to costs. Now, Your Honor, this case is exactly the same as the 5th DCA case of Steinmetz versus J.D. Parker-Sod. In that case, as in here, 2 individual plaintiffs, a husband and wife, and the company that they owned filed suit against one defendant. Now, the company that they owned did not prevail. The individuals did. On a subsequent appeal, the 5th DCA held that the defendant, even though the individual plaintiffs had prevailed, was still entitled to tax costs against the company because they recovered a judgment on those claims.
Well, what about the extent that the costs are duplicated?
Now,
Let's say there's a cost, $1,000 that was incurred prosecuting both cases. What's the trial judge supposed to do with that?
So in this is a very good question. This court answered that question in State Department of Transportation versus Vega. Now, the cost statute itself says that party recovering judgment shall recover all of his or her taxable costs.
Right.
All of the costs.
Right.
And in Vega, this court said that when you have multiple opposing parties and you prevail against one, recover a judgment against one but not the other, you're entitled to recover all of your costs unless, except for those costs that are solely attributable to prosecuting or defending your claim against the party that you did not recover a judgment on. So in this case, just like in Vega, our clients were defending against claims by 2 different sets of parties, the individual plaintiffs and the corporate plaintiffs. Recovered a judgment against one but not the other. Therefore, under the cost statute, entitled to recover all of our taxable costs, and as explained by this court in Vega.
So you would be seeking a remand to determine which costs were attributable to the Bill Rolland, Inc. case.
Exactly, Your Honor. The trial judge in this case never got to the issue of amount of costs and denied the motion altogether. So on remand, it's certainly available to the appellee to argue that certain costs that we're claiming are not attributable to the defense of their claims. They are solely attributable to the defense of the individual plaintiff's claims. Now, Your Honors, the situation where one party is litigating against multiple additional parties, it happens all the time. This court has held in those cases, that doesn't mean that the party that is defending or prosecuting against multiple claims has to recover against all opposing parties in order to recover costs. And for example, in the Whitesboro Park Estates case, there was one set of plaintiffs litigating against multiple defendants, all related defendants, all Harry Whitesboro and his various companies. The plaintiffs prevailed against some of those defendants, but not others. And even though all the defendants were related, it's all the same plaintiffs. The defendants that prevailed, that had a judgment in their favor, were entitled to tax costs, even though the plaintiffs did ultimately recover against other defendants. Same situation here. Even though our clients did have a judgment entered against them, and did have to are currently obligated to pay damages to the individual plaintiffs, we still recovered a judgment against appellee Bill Rolland, Inc. and therefore are
And that
entitled
was a
to tax
separate cause of
benefits.
action, correct?
Correct, Your Honor. Though Rolland Inc. Asserted a negligence cause of action, denominated separately, brought in its own name, and asserted a right to recover damages for breach of duty owed to it and damages to the company itself. And that included diminution of value of the company, loss of goodwill to the company, essentially a company reputation damage, as well as lost profits. Now that's separate from the individual plaintiff, William Rolland, who asserted a multiple cause of action, defamation, malicious prosecution, negligence, and asserted a right to recover damages to him, his personal reputational damages, his pain and suffering, his embarrassment and humiliation.
And the lifetime loss of consortium.
Correct, Your Honor. Now, because those claims are separate, and it's admitted in their brief that the company could have brought its claims as a separate lawsuit, separate cause of action, could have sued separately. And the Florida Supreme Court in Fulta v. Bolton, although it was an attorney's fees case, expressly applied the standards applicable to the cost statute, held that where causes of action are separate enough that they could have been brought in a separate lawsuit and sued separately, those claims are treated separately for purposes of taxing costs, or in that case, attorney's fees.
Well, here the statute says a party, so there's no reference to claims in the statute.
Correct, Your Honor. And it says the party recovering judgment. In our case, we are the party recovering judgment. And if the point in Volta was that you can recover a judgment on separate and distinct claims or cause of action that could have been brought in a separate lawsuit. And it's a matter of whether the judgment is separate. In this case, there's only one document called the judgment that enters judgment.
Well, there was a judgment entered in your favor against the company.
Correct. Even though that judgment also enters in favor of the individual plaintiffs, there is a separate section of that
But
judgment.
you could prevail on certain causes of action and not on others. They're
Correct.
separate.
Correct. And this is not a situation like the Florida Supreme Court dealt with at Hendry Tractor, where there's causes of action pled in the alternative, for example, strict liability and negligence, where the plaintiff can prevail on one, but not the other, and still get a judgment, an overall judgment in its favor. Here we don't even have the same party. We have completely separate parties asserting their separate claims, recovered a judgment against the public bill and under the statute we're entitled to costs for that.
Counsel, you are into your rebuttal time now, if you would like to save your 3 minutes.
I will. Thank you, Your Honors.
Good morning, counsel.
Good morning, Your Honors. May it please the Court. I'm Thomas Burns, and along with Robert Stickney and David Pollock, I represent Bill Rolland Inc. If we reach the merits, the question really turns on which prism do we look at this as if it were. So the question is this more like a Fulta situation or a Hendry Tractor situation? Our position is that this is a Hendry Tractor situation where the plaintiffs were asserting alternative theories of liability. And it's the appellant's position, I think, that this is more of a Fulta situation where there were separate and distinct claims.
Are you able to distinguish the Steinmetz case?
I'm sorry?
Are you able to distinguish?
Absolutely.
It's kind of the same thing, a husband and wife, and then
It's similar, but the key difference is that the parties there were asserting just totally different causes of action that really could be separated. The buyers there were asserting a fraud cause of action that had to do with the misrepresentation that was made during the sale. The company was asserting a breach of fiduciary duty claim, which had to do with the undertaking of the obligation in the first instance. Those are just two separate causes of action. They happen to be litigated together, but they're separate situations. And that's very much like a Fulta, the kind of situation that Fulta said, well, we can separate that. Because in Fulta, it was like, well, here's a medical malpractice claim. They've got claims against the nurses. They've got claims against the emergency room doctor. They've got claims against, this person who read, the radiologist who read the radiology report. And all of those things are separate. And so it's okay to say, well, if the plaintiff prevails on one claim but not on the other, that will have competing cost orders.
Did that case involve agency theory or employer-employee?
The way that the 5th District described it, are you talking about Fulta or
Fulta.
I don't believe so.
So all of those entities and whether they were under the hospital or
No, I don't think it did. I think it was just talking about whether those causes of action could be separated because they were based on different facts. And so they said, well, the claims against the nurses are based on, or sorry, the claim against the emergency room doctor is based on this initial presentation, and then the radiologist does his stuff a couple days later, and the nurses did something at this point in time. So each of those were like different points in time, and so because of that, you could separate them out and have competing cost orders. And our position is, well, that's what Steinmetz was doing. It was saying, well, you've got a totally different cause of action dealing with facts at different points in time, and therefore it's appropriate to have a cost order for one thing and a cost order for the other, and they can go in different directions. But that's not what we have here. What we have here is one set of facts, and that set of facts is litigated by the plaintiffs with alternative theories of liability. The bill says, well, negligence, malicious prosecution, defamation, and then there's consortium for the wife, and then the company also raises a negligence claim. But that's based on the same facts, so it couldn't be separated.
But would the trial court here on remand, if we were to remand, sort out what costs were attributable to which defense?
I don't know that you could. I think all these causes of action are just alternative theories of liability.
Well, isn't the loss of consortium clearly just pertaining to the wife?
Right, but it's... Oh, I see what you're saying. Yeah, yes, that's correct.
I mean, so that one you could clearly separate and
Right, but the key then is Bill and Bill Rolland Inc., and whether those are the same. And this, right now, the appellant is taking positions like, well, these are really different causes of action. They already said that in the trial court. They were the same. They said they were duplicative. That was part of their argument at the directed verdict here. So I think they're judicially stopped from making that argument. In fact, I made that point in our answer brief at page 31, note 10. They can't do that. They've already conceded this. And then they try and unconcede it in the reply brief, but that's too late. And they also didn't raise this argument below, so if you raise, what's your standard of review then on Steinmetz and that? These aren't arguments that were presented below, so your standard of review is plain error, or fundamental error. So,
isn't it not de novo on the interpretation of 5701?
well, that's an interesting question. So there's two parts of it. The interpretation of the statute is de novo, but the determination of who is the prevailing party, that's an abuse of discretion question. And that will be addressed in our answer brief. And the appellant here is not distinguishing between those two determinations. We're not saying that the trial court determined they were the prevailing party and then just refused to order costs. That would be reviewed de novo, and that would be a mistake. We're saying that the trial court did two things. One, he determined that they were not the prevailing party, and two, that given this order that you can interpret this way that he said, well, your cost would be zero. So what's the difference? You guys lose either way, and I'm just denying you costs.
Well, Rolland Inc. wasn't a prevailing party.
No,
I mean, would you agree? I'm going with
the question.
Rolland Inc. defending against the loss of consortium, get those costs, right?
I'm sorry, I have to restate that.
Rolland Inc. defended. I mean, Rolland Inc. prosecuted. Their claim did not involve loss of consortium.
The companies, correct? Yeah, the companies did not.
So there are no costs. Excuse me, I got confused.
Okay.
But I guess my point is, for me, I guess what I'm focusing on is Rolland Inc. wasn't the prevailing party, right? They lost.
No, well, our position is different. Our position is you have to look more holistically at what the plaintiffs were. Here you have two plaintiffs, two individual plaintiffs. It's the closely held, wholly owned corporation.
One of the individual plaintiffs,
yeah, the judge
a separate legal entity, brought a claim and lost.
I disagree with that. I don't think it's a separate legal entity in the sense that what are these causes of action and who do they belong to? So part of the interpretation you must do of the cost statute, you have to start with the common law. Common law rule is you bear your own costs and fees. And then they have to fit in.
Actually, the common law rule is you bear your own fees, but not your own costs, I thought.
The case that I cited said it was both.
Well, counsel, but isn't that exactly what Steinmetz said? And I'm quoting, there was no basis for the court to treat G.D. Parker Sod Inc. as the Johnson's alter ego.
Right.
G.D. Parker Sod Inc. brought suit in its own name, alleging a cause of action for breach of fiduciary duty. And then it goes on to say, having lost, Judy Parker's side, Inc. is liable for costs.
Correct. And there's two responses to that. One, you can either distinguish that as appropriately being a FOLTA situation, which I explained is like, well, you've got fraud and breach of fiduciary duty, and so you can separate those things. The second way of looking at it is like, well, if it's not a FOLTA situation, then they got the analysis wrong, because the way they should have Thank you. The way they should have looked at it was to say, to look at it with the property theory that we had looked at it with. So it's not really an alter ego kind of situation. It's like who owns the cause of action. And in common law, there's this chain of title that would go to the individuals, specifically in this case, the bill.
May I ask your question regarding let's talk about generally the pleadings. Okay, so the company filed its own negligence-based claims, correct?
Correct.
Now, there were, my understanding, I think, from reviewing the record, is when there was a motion for summary judgment that his client filed, the company filed its own opposition to the motion for summary judgment. That was separate and apart from the husband and wife, correct?
That's correct.
So why would they not be entitled then to recover for, excuse me, can you please turn that off?
Sorry, Your Honor.
Would it not be appropriate then for his client then to recover for having to address the arguments made in the company's opposition to that motion for summary judgment that was filed solely as to the company?
I don't think so, because it depends, like just going back to the beginning of my argument, it's which prism do you look at this through? Is this a FOLTA situation or a Henry Tractor situation? And so it all has to do is this an alternative theory of liability that they're asserting through a wholly owned, closely held corporation, or is this entirely a separate cause of action? And I don't see it as an entirely separate cause of action. It's just an alternative theory of liability that they conceded in the trial court was
How can it be
conflicted.
an alternative theory of liability? Because a corporate entity has, the allegation was that there was a breach of fiduciary duty, right? With respect to the company.
Are you talking about Steinmetz or?
Oh, I'm sorry, yes.
Sorry.
But
Okay.
with regards to this company, there was a separate cause of action that pertains solely to the corporate entity.
Right, and the difference is here it's about the same set of facts.
There was no
And in
allegation-
Steinmetz,
Well, there could be the same set of facts, but the problem is that the individual had a malicious prosecution claim, the husband. The wife had a separate cause of action, and the company had a separate cause of action, which is not, I mean, you can claim alternative theories, but they're different causes of action.
I don't think that's accurate in this one respect, and that is that Bill, the individual, also asserted negligence claims, and the company also asserted negligence claims. And so those causes of action are the same. It's based on the same set of facts, and it's just an alternative theory of liability trying to cover.
A duty to one and not the other. I mean, the court found there was no duty to the corporation.
Correct, and that was why that case, or why their claim got DD. But the difference is, this is just the difference I'm trying to explain about Steinmetz is it's an alternative theory of liability. It's not a separate cause of action.
I understand.
Okay, that's all I can
We've
accomplish.
let you go over your time, so you would ask us to affirm.
Asking you to affirm, and if you don't affirm, we're also asking you to provide the correct interpretation of Vega. Our position is that their interpretation of Vega is the opposite of how it should be. They're saying we're entitled to everything unless it's solely attributable to the company. And our position is no, that's not right. They're entitled to nothing unless it's solely attributable to the individuals. So if you were to reverse, you need to clarify that.
Any conclusion?
Please affirm. Thank you.
Okay, counsel, you have 3 minutes for rebuttal.
Our opposing counsel tried to distinguish this case from Steinmetz by arguing that in this case, all of the claims, whether asserted separately or separately by Rolland Inc. or by the individuals, arose from the same set of facts. And Steinmetz isn't quite clear. It seems like, from reading the case, they all arose to the same set of facts as well. But this court, for example, in Citizens Property Insurance Company versus Vasquez, addressed the situation where out of one one set of facts, one damage to a home, and property owner's cause of action is the insurance company for additional insurance funds for other property damage, and the insurance company's counterclaim for fraud for refund of certain property damage claims already paid. All those things arose from the same set of facts. This court held, however, that both parties, who both recovered a judgment under separate causes of action, were entitled to recover costs from each other. It's the same party. Here it's even more obvious that there's a separate party bringing the claims. It's not even the same party suing each other as it was in last case. Your Honor, my opposing counsel also tended to argue that the claims brought by the company were simply a different legal theory under which the individuals were seeking to recover damages based on the fact that they owned the shares of the company. And this law, Florida law is clear, and California law the same way, where this company was incorporated, that merely owning a share of a company does not mean that you own the company's property. It's a separate legal entity, the company, with a separate legal rights to its own property and its own cause of action. And indeed, in this case, the company sought.
Well, the allegation was that your client owed a duty to the company.
Correct.
And the trial court, a separate duty. And the trial court found that no duty was owed to the company.
Correct, Your Honor. Correct. And this was not, as my counsel represented, an agreement to a directed verdict. This was opposed. The trial court granted a directed verdict on the merits based on a lack of duty, not based on that the damages were entirely overlapped.
So what type of cost is your client seeking?
Our client is seeking, for example, the company's claims were for lost profits, loss of goodwill. There were experts hired to just go through the books of the company, the tax returns of the company, to figure out what those damages were. Opposing experts, their expert, our expert. There's depositions that involve, obviously, the factual basis of what happened that day. And then remember, this is a defamation and malicious prosecution claim as well. So the underlying facts were alleged that the...
So let's take the deposition regarding the defamation.
Right.
What would be the cost associated with that? Getting the depot, a copy of the depot?
Sure, Your Honor. So, for example, the copy of deposition of my client, Mr. Acuna, a defendant's deposition about the facts on that day, clearly relevant to defending both the claims of the individuals and the claims of the company. In this position, this court has already decided, based on Vega, those costs that are attributable to defending both causes of action, the cause of action we recovered a judgment on, and the cause of action we did not, are recoverable.
Recoverable by who?
By our clients.
Well, I would have thought that the plaintiff is entitled to recover all of its costs. The prevailing plaintiff is entitled to recover all of its costs, and the prevailing defendant is entitled to recover all of its costs. So
Correct, Your
when you
Honor.
have an overlap,
I'm
How's
speaking
the court
of both parties purchased the same deposition transcript. Do each have separate costs on this?
pardon?
If both parties purchased that deposition transcript, I'm saying whichever party incurred that cost is entitled to recover for that.
I'm sorry, I didn't hear that last part.
Whichever party incurred that cost related to the deposition, and if it's a joint shared cost between both the claims of the company and the claims of the individuals, would be able to recover that. But Your Honor brings up a good point, because the plaintiffs in this case also filed their motion to tax costs. And, for example, sought to recover the filing fee for the complaint, which asserted, obviously was filed on behalf of both the individual plaintiffs and the corporate plaintiffs. And they did not seek to parse out or to get rid of that cost.
How could you do that? How would you parse that? Huh?
You couldn't.
So they're the prevailing party.
Absolutely.
They're entitled to all costs. So it seems to me they get that cost.
I would agree with you. In the same way that our clients are the prevailing party and the party recovering judgment under the language of the statute against Bill Rolland, we would get those costs under Vega, all the costs that are attributable to defending both claims or solely the claims of Bill Rolland. If there are costs, such as Your Honor mentioned, let's say a loss of consortium claim, which does not involve the company's claims at all, those costs would likely not be recoverable. And it's up to the trial court to decide in the first instance, go through the costs, do the arguments of the parties, and decide which costs to award under the principles.
So those are findings of fact that the trial court needs to make.
Exactly, Your Honor.
All right, counsel, we'll let you go over. If you'd like to, in conclusion.
In conclusion, Your Honors, I would ask that you reverse the trial court's order denying motion tax costs and remand for decision by the trial court in the first instance, the amount and costs are entitled under the principles protected by this court in Bacon.
Thank you, counsel. Thank you both.